This is Samantha from the law offices of Samantha Wolfe, and I'm here today for our final installment talking about how to wrap up an estate. We've done two, part one and part two. One, how to open the estate. Two, talking about how to administer the estate. And today is our third and final installment of estate administration where we're talking about how to wrap up an estate. So I'm going to go ahead and get us started. Let me start at the beginning. Okay, there we go. So today is an easy path to estate administration. We're going to focus on wrapping up the estate. We've talked about this before. We do a lot of our virtual seminars because I feel like it's important to fulfill our mission statement to get the information out to our clients and referral sources. So always feel free to check out our YouTube channel or our website for information about our different seminars, newsletters, upcoming presentations. So let's talk about how to close an estate. So closing an estate, there are two main ways that you can do it. So the first is that it can be something where you're awarded final confirmation of the estate. Now, when we're talking about this, we're talking about from the perspective of the executor, because our office typically represents the executor who's administering the estate. So in order for the executor to close the estate, they can receive that final confirmation from the court. The second way to close it would be an at-risk distribution from the executor. And we're going to explain these two different ways to close. So the first is an award upon final confirmation of the account. We call it an adjudication of the account. So it's no longer a statutory duty for the executor to file an account. So the executor, the personal representative, may be compelled to file an account at any time after the expiration of 6 months from the first complete advertisement or sooner if directed by the court. So all that to say, it used to be the executor had to file an accounting. Now they don't have to unless they're compelled by the court or by someone petitioning the court. You can close it with the second option, which we'll go to in a minute here. So an account must have state of proposed distribution, meaning that the executor is going to compile a list of all of the assets, explain what's come into the estate, expenses that are paid, and then there's going to be a proposal of distribution out to the beneficiaries. You typically serve a copy of statement of account to all parties in interest, all the beneficiaries. If there's charities, you might have to do it to the Attorney General's office, but you're going to serve a statement with the account to all the parties. That then gives every person the opportunity to object to the proposed distribution. The executor is then going to file a petition for adjudication with the accounting. You're going to check the local rules as the executor, depending on what county you're filing in. And then the petition for adjudication can present questions to be resolved by the court if that needs to be done. But typically, you're going to say, this is the assets that I administered as the executor, these are the expenses I paid, and these are my proposed distributions out to the beneficiaries. That is important because when you get the confirmation from the court, it releases the executor of liability as long as all of the actions have been properly disclosed. So there's no point in filing accounting if you're not going to disclose everything. So disclose everything that you've done. The court then reviews it, signs off on it, and then that resolves you or releases you of liability. What is an accounting? It shows what property there was, what happened to it, and what's left. So you begin with the assets included in the estate or trust. The fiduciary should separate principal from income, meaning the executor is going to show what was principal and what was the income generated off that. After listing the principal, you're then going to show the sales or the dispositions that you've done of the asset. So meaning if there's real estate and you sold it, this is what you got from it, this is how you distribute it, or you're proposing to distribute it. Then you're going to show items paid out of principal, including distributions chargeable to principal. So if you've made like partial distributions throughout the administrative phase to the beneficiaries, you're going to show that. You're going to have income schedules, payment out of the income, and then you're going to show the balance that you have left that you're proposing to distribute to the beneficiaries. That's the first way. The second way you can close the estate is that you can do a voluntary distribution. Now we call this an at-risk distribution because it's not ordered by the court, meaning you haven't gotten court approval. It's typically done through a family settlement agreement or through a judicial settlement agreement, meaning that The executor puts together a proposed distribution, sends it to all the beneficiaries, and gets them to sign off on it. And then if all the beneficiaries sign off on it, then they distribute. It is now the normal way to close an estate. It's customary and less expensive than seeking court approval. Now, the executor does assume risk of distributing to the wrong people, and they would be personally liable for unsatisfied claims against the estate. That's why in certain situations we still recommend that the executor, the personal representative, file to get that court accounting and that court adjudication. But you can close it without that, as long as you have all the beneficiaries sign off. So typically there's a receipt and a release and a refunding agreement, meaning that the receipt is showing this is the distribution we're proposing. The release is where the beneficiary is saying, I acknowledge that, and I'm signing off saying that I will receive the funds and agree to release the executor of liability. And then typically there's a provision in there that says that if the executor made a mistake or calculated it wrong, the beneficiary agrees to refund the executor the distribution. The document needs to recite all the facts, have any disclosures in there about what happened with assets, put any consideration, for example, what's the executor being paid, what's the attorney being paid, all of that's going to be in there. And then the executor may file copies with the court or the register and recorder, and then anybody who received at-risk distributions, but it doesn't constitute court approval. So you're going to file it, but it's not saying that the court has approved the distribution. The personal representative or the executor is not liable to any creditor who failed to give notice of a claim within 1 year of the first complete advertisement of the grant of letters. We talked about the advertisements in part 1 and part 2 of the estate administration process. So go back and check that out if you have questions about it. But the good news is that if there is a creditor that comes forward and it's been a year, they're barred from bringing any type of claim. You can make a partial distribution. So I see partial distributions when we aren't closing it with a formal accounting. If we're going to do the family settlement agreement or the judicial settlement option and the executor wants to make partial distributions, they can do that throughout the administrative phase before the administration is complete. Often the estate is mostly administered, but maybe there's you're waiting for the all clear for the inheritance tax return or the income tax returns to be filed. And so you're going ahead and making a partial distribution. And then what we do is we hold a reserve. So we might say we're going to distribute everything but $5,000 until we get the all clear from PA. That way, if any additional bills come in, or if there's an additional tax that's due, we have the funds to pay it. When you do the final distribution can occur once you've received the Department of Revenue inheritance tax appraisement, because remember, you have to file an inheritance tax return. We talked about that in part 2. Usually it takes the Department of Revenue 4 to 6 months to approve that return. Once it's approved, then they issue what we call an appraisement, where they say, we've reviewed everything looks good, so we're going to approve it. Once you get that appraisement, then you can make the final distribution of that reservation. In my example from the last slide, if we keep $5,000, once we get that appraisement back from PA, we can then distribute that $5,000. That also, to close it, or final distribution, when the creditor claim period has ended. So typically it's once 1 year from the advertisement has happened and there's no estate administration tasks that have occurred. That's why the estate administration process takes so long, is because we're waiting on the Department of Revenue to come back and say that they've reviewed everything and agree with it. And we're waiting for the 1 year from the date of the first advertisement to make sure no creditors come forward. Once that's done and we're making the final distribution out, we then file a status report with the Register of Wills informing them that the estate administration process is complete. Post-administration issues, sometimes there might be checks that are payable to the estate after we've closed it. And so the question is, can we get that reissued, or how do we handle that? That's where you're going to talk to the attorney that's helping you administer the estate. There might be newly discovered assets, and so you might have to file a supplemental return because there's inheritance tax due. So you might want to talk to your attorney about when that is recommended and what amount does it have to be in order to file the supplemental return. Typically, if you're filing a supplemental return, There's going to be interest and penalties because most of the time that's after you've already filed the initial return and it's post 9 months, meaning that you've already missed the deadline to pay it. And so there would typically be interest and penalties. And there might be a complaint filed by a beneficiary. So if this happens, then you're going to want to make sure you're partnering with an attorney that has litigation experience so that you can make sure that somebody is advocating and defending you in that case. Now, the goal is to administer an estate without having those issues and to be able to close it without having any concerns with the executor there being a claim. So that's why you either want to make sure you're filing the accounting with the court and getting the court adjudication, or you want to make sure that you're making the distribution with those releases, the family settlement agreement or the judicial settlement option. So that way we make sure that you're covered and nobody's going to have any legal recourse. Next steps. You can always call our office at 717-655-2676 to schedule an initial consultation. We can walk you through the estate administration process. The best way to help your executors to make sure you have a good estate plan in place. So we always recommend that you start with having good estate planning documents, and then that will help your executor when they're administering the estate because it's so much easier. So hopefully this is helpful. This was part 3, wrapping up the estate. If you're watching this video first, go back and watch part 1, which is opening the estate, part 2, which is the administration portion of it, and then finish with this one, which is wrapping up the estate. I'm Samantha with the law offices of Samantha Wolfe. Thank you so much for joining me. We hope this is helpful. Be sure to check out our YouTube channel for other videos. Thank you so much.